Hello, welcome to our live online audience to the session 36th anniversary of the UN Basic Principles on the Independence of the Judiciary, reflecting on contemporary challenges of judges and lawyers around the world. My name's Sarah. I'll be the host for this session, and I just have to read one quick COVID statement before we begin. As you are all aware, mitigating the risk of spreading COVID-19 during the Congress requires the cooperation of all of us. In line with the COVID-19 prevention concept elaborated by our host country, Japan, and the Secretariat, I would like to kindly remind you of the following precautionary measures. Please fill in the contact tracing information sheet if you are in person. Maintain at least 2 meters of physical distance from each other. Wear your FFP2 mask at all times. Do not attend any meetings if you are unwell, and if you feel ill during a Congress session, please contact the medical personnel. These measures are in place for the safety of all of us, and I thank you for your support and attention. And I will now pass it on to Mr. Diego to moderate the session.
Hello, everybody. Good morning to all you that have the luck to be in Kyoto. Good evening or good afternoon with people in other places of the world. Dear colleagues, dear participants, I am highly honored to lead this side event and with the participation of such a qualified panel, very good friends and distinguished jurists, all of them with a solid track record in the affirmation of rule of law and human rights. Unfortunately, the well-known health conditions that is affecting the world has forced most of the participants in this conference and this event to do it by virtual means. But it is very important that we are here today. We will have the participation of 5 highly skilled jurists that will share with us views from different kinds of institutions in different parts of the world: Asia, Africa, Europe, Latin America, and the United Nations. To analyze the close relationship between an independent justice and an effective confrontation of corruptions, we count with a qualified participation first of Judge José Igreja Matos, President of the European Association of Judges and first Vice President of the International Association of Judges. Then of Judge Luz Ibáñez, Judge of the International Criminal Court, who will refer to the relevance of the obligations of the states concerning the independence of the International Criminal Court. After, we will hear Public Prosecutor Shel Kyu-hwan, President of the International Association of Prosecutors and Chief Prosecutor of International Center for Criminal Justice of Korea. Then, we will hear Judge Measa Asnehafi. She is Chief Justice of the Supreme Court of Ethiopia, country which its 112 million of inhabitants is the second in population in Africa. She will speak about the evolutions taking place in her country to establish a more independent and more legitimate system of justice. Finally, we will have the opportunity to hear Marco Teixeira, Senior Program Officer of UNODC, based in Vienna, and head of the Doha Declaration Global Program. Dear participants, we are facing in the world increasing threats and attacks to judicial independence coming from organized or transnational corruption. Part of their modus operandi is the penetration of institutions in the justice sector. Through illicit and violent interferences with regards to the justice system in the state, they seek impunity, closing particular cases, or forcing acquittal of a given individual. The original notion of the UN Basic Principles on Independence of Judges, adopted in 1985, 31 years ago, was that judicial systems have to be independent of the other branches of government, primarily the executive and legislative branches. 5 years later, the guidelines on the role of prosecutors were adopted at the UN in 1990, among with their obligations to carry out their functions impartially and avoiding all political, social, religious, racial, cultural, sexual, or any other kind of discrimination. That fundamental concepts, of course, remain fully and completely valid. However, organized and transnational corruption against judicial integrity and independence is a major contemporary threat that was not considered in the basic principles adopted more than 30 years ago. This places major and new challenges to contemporary judiciaries worldwide, while it's precisely judges, justice, and public prosecutors the main instrument to confront and defeat corruption. An empowered society and an independent judiciary and public prosecutorial service is crucial in this challenging context. Four crucial components seem to be decisive so to strengthen the standards, so to successfully confront corruption internationally and nationally. First, the United Nations Convention Against Corruption. This global treaty has fixed unprecedented clear rules and standards addressing global and transnational corruption and its effects on society and institutions, including the judiciary. The international community has in this convention one of the most important treaties adopted in the last decades. In it, judges and prosecutors have the fundamental role to play. Second, the very important and positive worldwide movement of judges, public prosecutors, and lawyers. In this, judges and prosecutors are the key actors, and organizations like the International Association of Judges, here represented by Jose Greya Matos, and the International Association of Prosecutors, here represented by its president, Xiol Q. Huang. These institutional processes are crucial to affirm the independence of judicial and prosecutorial institutions and to confront corruption with proper and independent investigations and criminal processes in courts. Considering, among other instruments, the fantastic rules of international cooperation adopted in the Convention. We have several recent examples of what can be called success stories in ongoing investigations in different parts of the world on criminal prosecutions and big schemes of corruption. International judicial cooperation, however, could be seriously hampered and threatened if judicial and prosecutorial institutions are not fully independent. Who will trust in a judge or a prosecutor of other country for an extradition process which one knows is not independent? Their international legitimacy fructifies when they act without biases and based only in the results of independent and credible investigation. This approach is of paramount importance so to effectively face impunity of transnational corruption and organized crime in crucial matters such as extradition or international mutual legal assistance. Third, the more independent the judiciary is, the less effective will corrupt practices be utilized successfully by transnational organized criminal groups, particularly in their interaction between organized crime members with the private sector in their attempt to influence politicians in the judiciary seeking to obtain impunity. Hence, it is relevant to both judges and prosecutors to have the necessary protections recognized in international instruments to ensure their independence and impartiality vis-a-vis any interest that could threaten or affect them. Among other provisions, Article 11 of the Convention, which requires that each state party takes sufficient measures to strengthen the integrity of the judicial system and avoid any chance of corruption among its members without prejudice to its independence. Fourth, the crucial and vivid interaction between independence and integrity. That is, between the standards and provisions of the UN Basic Principles on Independence of the Judiciary and the Bangalore Principles adopted by the UN as well to establish an international standard for the ethical conduct of judges. The Bangalore Principles outlined the values that are referred to these very crucial matters of integrity, independence, impartiality, correctness, equality, and competence as necessary values for ethical judicial conduct. In addition, they aim to safeguard judicial independence by establishing the necessary conditions to promote the ethical conduct of members of the judiciary. Judicial integrity then highly correlates with judicial independence. Marco Teixeira will share with us some key aspects referred to this interaction and specifically to the Global Integrity Network, of whose advisory board I am very honored to be member. Dear colleagues, dear friends, the ongoing health crisis is eroding economic and social stability, context in which a functioning judiciary is more essential than ever. Special and additional threats of corruption and additional challenges to an independent judiciary are being faced worldwide with the impact of the pandemic. The increased complexities to achieve proper access to a functioning independent justice is being threatened and attacked in several parts of the world by abusive behaviors and risk of impunity in areas like domestic violence and in other sensitive and crucial matters like corruption. While the impact of the pandemic may last for many years, there are some special challenges that could be taken into urgent consideration so to guide short and long-term policies. I will summarize, and with this I will end my presentation, in four crucial aspects. First, increase the support and guarantees of independence of justice, bringing justice closer to the people, as well as encouraging creative steps in the appropriate decision-taking processes in this direction, increasing resources. Additional finance to fill the justice gap should be included in all stimulus and bailout packages. Second, a streamline on the services being provided by the justice system may lead to establish certain priorities that should be guided with substantial criteria, so to prevent social exclusion, domestic violence, guarantee of human rights, and confront corruption. Third, innovation and online technology for courts operation. Providing the capacity to use proper online technologies must be addressed, paying first special attention to existing technological gaps and due processes, among other things, guaranteeing private communications between lawyers and their defendants. And fourth, special attention must be paid to the human rights of incarcerated people. More effective steps should be taken worldwide so that pre-trial detentions are applied only in very extraordinary and specific circumstances. Dear colleagues and dear friends, the principles that were established as international standards already for more than 35 years are clear and solid. They have been reinforced by fundamental provisions of the Convention Against Corruption and by the energy of judges and prosecutors in different parts of the world to confront corruption. The remaining and new challenges created by the pandemic can be successfully met with these available tools and energy. Thank you. I will finish my presentation here and give the floor to my good friend, the President of the European Association of Judges and first Vice President of the International Association of Judges, Jose Igreja Matos. Jose, please.
Thank you, Diego. First and foremost, allow me to vividly thank the organizers the welcome opportunity to be here. I also warmly salute the other panelists that I already knew and admire. Some of them are very esteemed friends. As first Vice President of the International Association of Judges, the largest organization of judges in the world with national associations representing 92 countries, I believe it is mandatory to underline the crucial role of United Nations, and in particular of its special rapporteur on the independence of judges and lawyers to the safeguard of rule of law for the past decades. Particularly important has been the work developed by Mr. Diego Garcia-Sayan. In recent years, with the decay of rule of law in Europe, particularly in some countries and regions, Mr. Diego Garcia-Sayan always responded to our requests of assistance and support. He is relentlessly a defender of the causes that compose the core mission of the European Association of Judges. His devoted commitment to protect the human rights, along with those who assist him, must be publicly and sincerely praised. And this is the right moment, this is the right place to do so. Being president of the European Association of Judges, it must be emphasized that the situation of the judiciary in my continent, on an era of autocratic and populist regimes with recurrent obituary articles on the death of democracy, is today of concern, even of angst or fear, when assessing the quality of judicial independence. Aggravating the problem, the ongoing pandemic hardened the dystopian temptations of some political regimes. For these reasons, it gains additional importance to celebrate the anniversary of the basic principles on the independence of the judiciary. The UN Basic Principles are an essential tool as a set of international norms to uphold the independence of the judiciary against various forms of threats put in place by both state institutions and private actors. Allow me to present a concrete and very recent example. The system of appointment of judges, in particular for superior courts, supreme courts, or constitutional tribunals, and the elections of members for judicial councils or similar bodies. In several countries, merit criteria and transparent procedures have been often neglected, if not abandoned, replaced by the protection of particular interests of powerful political groups. On the other hand, when holding meetings with representatives of European institutions in our multiple discussions, it was always often pointed out that the domestication of judges encourages the impunity of corruption schemes, from the common ones, trade-off of favors, to the most serious, bribes, venality of judges, transnational money laundering, to others equally hurtful, the system of revolving doors between politicians and judges, the issues of conflict of interests, and the inefficient control by supposedly independent oversight authorities. The capture of the judiciary by external interests of outsiders, the debacle of judicial independence has, I dare to say, another alarming outcome: the inevitable absence of judicial integrity in a background particularly demanding vis-à-vis the robust ethical values required for judges, stated by the Bangalore Principles and concretely reaffirmed in the present days, again, yet by United Nations in yet another fundamental project for the quality of judicial systems, the Global Judicial Integrity Network. Having in mind the United Nations agenda and its goals, how can this persistent state of affairs be reversed? First of all, structurally, we must underline the leading role of judicial cooperation and its decisive responsibility to shield the value of rule of law. The globalization of our problems, transnational criminal networks, as already pointed out by Diego Garcia-Sayan, fake news in internet and social media, disdain of science, the so-called surveillance capitalism, calls for global answers. Global problems, global answers. As Antonio Guterres pointed out, the world's problems of today transcend the borders. In hypermodern societies, the causes for violent divisions caused by the nationalism, the populism, the racism, are mostly promoted by the derision of the fundamental value of universality that unified us decades ago. Therefore, judicial cooperation, international partnerships are more crucial today than ever before. The time has come to underline the critical importance of global institutions steered by universal values: rule of law, judicial independence, judicial integrity, fight against corruption, and to explain to civil societies how essential are their findings and, even more, the effective implementation of their guidelines and of their recommendations. Acknowledging the need of reassessment more adapted to the present days, in 2017, the International Associations of Judges General Assembly revised its Universal Charter of the Judge. Updated rules were added to the first version of 1999, in particular those related with more modern topics. Again, the appointment of judges, disciplinary procedures, the practical embodiment of transparency rules. Transparency, not its illusion, is the new objectivity. There is a clear evidence that a judicial system with a traditional high degree of transparency is a paramount safeguard against corruption. The long history of United Nations and its structural pledge to uphold judicial independence became today a fundamental means to envision the future. The home for our judiciaries, a home that must be always supportive, empathetic, universal, is for us to build now in the present with the tools of the past and the plans for the future. As Einstein taught us, the distinction between past, present, and future is only a stubbornly persistent illusion. Thus, we need to strengthen the United Nations' basic principles of judicial independence as a more concrete tool for the arduous times in which we live. Options such an addendum in the form of an official commentary to supplement the existent content of the basic principles, tackling with concrete examples and an updated approach, at the end emulating and fostering the lessons learned of detailed commentary on the Bangalore principles of judicial conduct, can be a recommendable way forward. The European Association of Judges has been confronted in recent years with a permanent erosion of judicial independence. You know well the countries involved, some of them European Union members. We learned many lessons during this painful process, but one of the most decisive was that little can be done on an individual level. Not enough can be done on a national level. We need global networks to affirm the universality of our values, insisting as much as needed that only judicial independence, impartial courts can successfully protect human rights. Because in the end of the day, as Kofi Annan stated, we will not enjoy security without development. We will not enjoy development without security, and we will not enjoy either without respect for human rights. Thank you very much for your kind attention.
Thank you very much, Jose, by your excellent presentations, and thank you, first of all, for your very generous words regarding the function I am fulfilling as a special rapporteur. It's my duty to do what I am doing. That's my mandate, and of course, very important, the reference you have made to the need of the updating of the basic principles, which may be done through different ways, perhaps in addition to what we have as basic principles, perhaps by a succession of declarations, of statements made, for instance, in conferences like the one that has been inaugurated yesterday in Kyoto. That would be a fantastic thing to as a way to follow up. Now I will give the floor to Luz Ibanez. Luz Ibanez is a judge of the International Criminal Court, as has been already presented. And among other things, Luz will share her views with us by a video. He will, among other things, will comment how this matter of independence is relevant as well for an international court, and specifically for a court like the International Criminal Court, which is a view that not generally is mentioned in this kind of conferences. So with the support of the Secretariat, I will give the floor to Luz Ibanez in the video that she had sent today some hours ago. Please.
Good morning to everybody. I would like to thank the organizers and the Special Rapporteur for Judicial Independence for inviting me to this event. I am honored to participate in these reflections regarding the contemporary challenges surrounding the fundamental principle of judicial independence and what can be done in the future, especially at the International Criminal Court, where I belong as a judge. In my view, judicial independence is at the same time an inherent attribute of the judiciary, a human right, and a duty of the judge to defend. It is also a guarantee of fair justice and basis for the rule of law. It is not a privilege of the judge, but rather an entitlement afforded to him or her because of the fundamental functions judges perform. In order to ensure judicial integrity and ultimately fair justice, a judge must be independent and respond only to his or her conscience, the applicable law, and the facts and the evidence of a given case. Judicial independence is enshrined in human rights law and various international instruments, and of course, developed in the UN Basic Principles on the Independence of Judiciary and the Bangalore Principles. This fundamental principle is also recognized in Article 40 of the Rome Statute and in Article 3 of the ICC Code of Judicial Ethics. Judicial independence consecrates the guarantee of separation of powers to avoid arbitrariness. Diagnostic at the ICC. Now, turning to the main problems of the ICC in terms of judicial independence, I must start by recalling that this court has jurisdiction over the most serious international crimes, such as crimes against humanity, war crimes, genocide, and the crime of aggression, which are generally surrounded by political issues and embedded in an unstable international context. As such, various actors may attempt to interfere with the proper functioning of the court and thereby threaten the independence of judges. The court faces two main kinds of threats and attacks, those coming from external sources and those from internal sources. With respect to external sources, first, the court faces threats and real attacks from great political powers seeking to dissuade the judges from action or to influence judges to rule in their interests. Political or de facto powers use economic sanctions, visa restrictions, and other such attacks as forms of undue political interference. Second, the court faces attacks from mass media conglomerates, almost always in support of great political powers, through targeted media campaigns seeking to discredit the court and its judges. I am not referring to the opinions expressed in blogs or other platforms, but rather to extensive campaigns of malevolent media powers to delegitimize the very existence of the court. The third external challenge relates to the legislative and executive organ of the ICC. It is the Assembly of States Parties, made up of 123 states parties, which can sometimes confuse its role such that the independence of ICC judges is threatened. That is, when states parties attempt to take on a role of supervision or oversight of judges. This is not only, by definition, impossible, given the principle of separation of powers, but also deeply at odds with judicial independence. Now, in terms of ICC internal challenges, these are related to the fact that the court is a young institution that has been in operation for less than 20 years. As such, there's still a lack of adequate institutionalization. One internal challenge is that there can be confusion within the presidency of the court with respect to its role as an administrative power, which should not interfere with the rights of the judges, such as their right to freedom of speech. A second internal challenge arises from the lack of transparency and clarity in the court's protocols and internal processes. For example, judges who are not assigned certain important cases may be put in the position where their judicial independence is at risk of being sacrificed at the expense of getting more meaningful work. This challenge relates to the need to acknowledge all ICC judges as equal. Third, and finally, another internal challenge is gender-related, and by this I mean not only the issue of gender parity, which has thankfully finally been achieved among ICC judges as of this week, but I mean that the voices of female judges have been easily silenced in a male-dominated environment. Conclusions and recommendations. After outlining these challenges, I must stress that the UN Basic Principles on the independence of the judiciary and the Bangalore Principles are directed towards states. Thus, the 123 states parties to the Rome Statute have an obligation not only to adhere to these principles domestically, but also to guarantee them for the ICC judges in order to ensure their adequate performance. In terms of external challenges I have discussed, I note that the court is the product of a common understanding of the international community, and as such, the defense of the judicial independence must be ensured by this international community, and in particular by the state parties of the Rome Statute. This can be complemented by joint action of judges around the world in support of ICC judges. The judicial independence of the ICC judges needs to be structurally protected by international community, civil society, and other stakeholders. In terms of enhancing UN basic principles on the independence of the judiciary and the Bangalore Principles, it is key to understand that equality also means diversity and the respect of diversity. In relation to the principle of competence and diligence, judges and legal staff should receive permanent ongoing training and capacity building, since the world is not static and international law is constantly evolving. Finally, I would like to recall that the defense of judicial independence is not a task belonging only to individual judges, but a task of a broader society, and in the case of the international judges, it is a task shared by the international community. I therefore call for your action in promotion and in defense of the judicial independence of ICC judges. And by doing so, you will be safeguarding the basis of the rule of law, peace, and global security. Thank you very much.
Thank you. Thank you very much to Lucy Ibanez for her very vibrant and concrete presentation, sharing with us a view which is not usual to hear about these challenges and threats against independence that may exist even in international courts when they are dealing with big and difficult matters like crimes, war crimes, and crimes against humanity. Thank you very much for this very relevant presentation. And I will give the floor now to my friend, President of the International Association of Prosecutors, Shol Q. Huang, that will share with us his views. He's one of the few lucky members of our group that is able to be in Kyoto right now. So, Shulkyu, please, I give you the floor.
Hello. Distinguished panelists and participants, my name is Cheol-Gyu Hwang, and I am very glad to meet you all as President of the International Association of Prosecutors, IAP. It's a great honor and privilege to be invited as a panelist in this meaningful and important event. Allow me also to thank you, Mr. Diego Garcia-Sayan, UN Special Rapporteur on independence of judges and lawyers, for making this possible. IAP is the only global organization among prosecutors around the world, currently encompassing some 350,000 prosecutors of 177 countries and territories. It was founded 26 years ago in Vienna with the support of the United Nations. It is working hard to realize the rule of law and protect human rights with its secretariat in The Hague, Netherlands. 36 years ago, the basic principle on independence of the judiciary cited threats and challenges that would negatively affect the independence of judiciary and the impartiality of its judgment, and clarified its position to firmly eradicate them. Despite the UN principle above and the subsequent efforts, threats and challenges have continued to evolve over a long period of time, and the subjects and methods of such action have diversified and intellectualized. And in some countries, relevant crises are getting worse and worse. In this context, with the UN-based principle as a starting point, today's event is very timely, addressing the issue of independence across the overall judiciary from the present perspective. I wish, through productive discussions, we could come up with reasonable measures for future implementation. Today, on behalf of IAP, I will introduce various efforts IAP has made so far to protect the independence and integrity of the prosecution and elaborate my opinion on how to cope with those incessant threats and challenges to the prosecutors. Regarding the threats and challenges, we can reckon various conciliations and pressures from the executive, the legislature, public opinion, the media, civic groups, multinational cooperatives, and even criminal organizations. By faithfully implementing and disseminating the causes defined in the UN Basic Principle and the various international standards and norms set thereupon, including Article 11 of the UN Convention Against Corruption, IAP is doing its best to ensure the prosecutors fulfill their responsibilities in independence and integrity without wavering in spite of those obstacles. From its inception, IAP has stipulated independence and integrity of the prosecution in its constitution as a fundamental objectives and continuously promoted and supported it. Thereafter, building on 1990 UN guidelines on the role of prosecutors, IAP has meticulously drafted and adopted the IAP standards of professional responsibility and the statement of the essential duties and rights of the prosecutors in 1999. Article 2 of the standards directly addresses the institutional and functional independence. Independence and integrity is the consistent spirit running through the IAP standards. In 2014, systemizing the standards in detail to make them more functional, IAP published the guide booklet on the status and roles of prosecutors in cooperation with UNODC. It was released to assist the UN member states in maintaining and developing their own prosecution system by referring to it. Let me show you this booklet. And then it's like this. It has always been the case that all IAP organizational members are requested to certify their operations are consistent with the standards and guide booklet. Furthermore, IAP actively advocates for the fundamental independence of prosecutors, monitors threats to their safety and security, and supports the development of practical strategies against those threats. Especially when huge corruption cases are handled by the prosecution, they are very likely to take high profile in size and importance, which may result in direct or indirect threats to the prosecutors in charge and receive appeasement and intimidation in different forms and methods. IAP operates a worldwide program for prosecutors in difficulty, PID, and related standing committee that plays a vital role in safeguarding interests of prosecutors and ensure that when prosecutors seek assistance, they get the support they need. As a recent reference, IAP completed examining the PID program last year and expressed deep concern about threats to the prosecutor and major officers of the International Criminal Court, announcing 2 consecutive public statements. IAP late last year inaugurated Global Training Academy project, which would provide members worldwide with a coherent training program. Training covers a range of topics from international cooperation to specialist networking against cross-border crimes. All training will have IAP standards embedded within, namely universal professional standards transcending national borders, and there will be modules dedicated to prosecutorial independence and integrity. When it comes to independence and integrity observance in reality, various codified rules and systems of each country play an important role. But more important is the will of the prosecution and prosecutors in each country, and the overall cultural aspect respecting them inside and outside the prosecution. In addition, paradoxically indeed, many states with a strong culture of prosecutorial independence and a high degree of public trust in justice system actually feature few formal indicia of independent prosecutorial power vis-à-vis the executive or other branches of the government. Conversely, this paradox may reflect the reality that countries have struggled to maintain independence and neutrality of prosecution and may have been forced to reform to codify those purposes. But codification not mean cultural changes. State capture and corruption remain problematic even with formal change of rules. Moreover, in recent years, authoritarian governments are increasing in number and trying to concentrate rather than separate powers. Especially since last year, various COVID-19 related controls have led to restriction of access to justice system. As those trends have a significant negative impact on its operations, many countries are in serious situation in terms of the prosecutorial independence. It is why IAP has been making unstinted and all-out efforts to spread awareness of independence and integrity among prosecutions and prosecutors through various opportunities, such as IAP annual conferences, regional conferences, training and education activities, and other engaging measures. The main theme of 23rd IAP Annual Conference in Johannesburg in 2018 was Prosecutorial Independence, the Cornerstone of Justice to Society. And in 2019, at the 24th Congress Annual Conference in Buenos Aires, prosecutorial independence was the subject of a forum with a video presentation by UN Special Rapporteur, Mr. Diego Garcia-Sayan. Since 2020, amid the dire COVID-19 pandemic, IAP efforts have continuously been exerted to protect and propagate the independence of prosecutors through a variety of online or hybrid events and meetings, including this UN Congress in Kyoto. In conclusion, prosecutors are cardinal gatekeepers of the judicial system, justice system, and have immense responsibility to maintain rule of law and to protect human rights through day-to-day fulfillment of responsibilities at all levels. It is also widely recognized that the independence of prosecutors is crucial to a democratic society and essential for the independence of the entire justice system. Therefore, prosecutors should keep in mind that in any difficult circumstances, they should continue to make every effort to uphold the independence of the prosecution and rule of law. It is equally essential that prosecutors work together through solidarity and collaboration across borders to ensure that independence is maintained. Thank you for your listening. I wish you all the best.
Thank you very much, Seolki Hwang, President of the International Association of Prosecutors, for this very consistent presentation that raises these values of independence that should be part not only of the role of judges but of public prosecutors, as you have rightly said and mentioned. Now I will give the floor to our friend, the Chief Justice of the Supreme Court of Ethiopia, Judge Meassa Askenafi. At this time, this meeting would be at 3 o'clock of the morning in Addis Ababa, so it's understandable that it will be very difficult to have the possibility to have her with us. Well, there are a lot of very relevant activities taking part in her court tomorrow morning. So please, with the support of the Secretary, Sarah, please give the floor to Judge Askenafi.
Greetings to our moderator, Special Rapporteur, Mr. Diego Garcia-Sayan, distinguished speakers, and all in attendance of this panel. Happy International Women's Day. I am very pleased to be part of this panel. I wish I deliver my message live, but the time difference has made it inconvenient. Ladies and gentlemen, my intervention will focus on two critical issues of judicial administration, namely judicial independence and judicial integrity. We all know that courts are the centerpiece of the judicial system. We are also aware that judicial independence is absolutely necessary for the proper functioning of the judiciary in a democratic society. This is affirmed by international and national principles and laws. The UN Basic Principle on the Independence of the Judiciary sets standards that member states should follow on matters ranging from institutional independence of the judiciary to independence of judges. Ladies and gentlemen, let me share with you a few of the measures taken to entrench judicial independence since my appointment as the Chief Justice in November 2018. This is also the time when the country embarked on an inspiring yet challenging road to a democratic transition. In January 2021, following a long deliberative process that started in mid-2019, the Federal Parliament has adopted two key legislations. One dealing with the Judicial Administrative Council, and a second one dealing with the federal court structure and important aspects of judicial administration. Those laws have expanded and created an enabling context to build strong, independent, and impartial judiciary. In implementing the legislative reform, the salary and benefit packages of judges have been revised and improved. The benefit package includes provision of residential facilities to federal judges. In terms of creating an impact on quality of judicial service, judges are trained and consistently encouraged to be impartial and to practice fair trial with due process. And this is delivering results. These actions are taken because we understand that it is critical to restore public confidence in a judiciary that has a long-standing history of public confidence crisis. Building a competent, impartial, and independent judiciary is an incremental process that requires multifaceted reinforcements. However, we feel we are on the right track. Change is coming to our judiciary. Ladies and gentlemen, our process is not without challenges. Given the challenging democratic transition in our country, we have witnessed, in some cases, a tendency to neglect or delay enforcement of court decisions. In few cases, judges are also harassed and attacked. The Plenum Forum of Federal and Regional Courts that I chair has openly condemned such practices. We will remain vigilant about these issues. Under some conditions, enforcement of judges' decisions and securing their safety may not be taken for granted. This should be one of the dimensions that need to be considered during the revision of the UN Basic Principles. Given that such principles are a direct attack on the very essence of judicial independence. Mr. Moderator, let me move to the issue of judicial integrity and make few comments. In ensuring the independence of judges, emphasis has to be given that judges need independence for the proper performance of their duties without abuse or fear of third parties in power. Judges should be mindful of using their independence to protect the rights of others, rather than exploit the same for their own personal advantage. There is a growing recognition that while independence of judges is being promoted, activities that are causing integrity problems on the judiciary is not getting a similar attention. In several jurisdictions, corruption remains one of the key challenges affecting judicial integrity and eroding public confidence. Beyond and above adopting judicial code of conduct, innovative and methodic approaches needed to tackle the problem. The UN Basic Principle should address the issue of judicial integrity in line with the Bangalore Principle of Judicial Conduct. Mr. Moderator. My final comment for future consideration is to integrate sufficient resource allocation framework to the judiciary from national budgets. Such measures is important since there have been occasions when the government takes retaliating measures by shrinking budget allocation when court decision is not to its liking, particularly regarding decisions related to electoral dispute. Some jurisdictions allocate by law a certain percentage of national budget. In others, the budget to be allocated for the judiciary is not necessarily earmarked. Hence, in promoting judicial independence and integrity, it is important to have an international standard on minimum budget to be allocated for the judiciary. Thank you very much for your attention.
Thank you very much, Madam Chief Justice of the Supreme Court of Ethiopia. Thank you for sharing with us this very positive and optimistic view of the evolution taking place in your country, so to affirm a judicial independence in Ethiopia. And thank you as well for your analysis of the interaction between judicial independence and integrity as two core substantial values of justice in the world. Now it's a pleasure for me to give the floor to Marco Teixeira. He's as well one of the few lucky ones which is as well in Tokyo. He's the Senior Program Officer of UNODC and head of the Doha Declaration of the Global Program, and pushing forward very strongly the affirmation and the consolidation of the principles of integrity worldwide through the global network in which Marco is one of the key components and promoters. Please, Marco, you have the floor.
Good morning from Kyoto. Thank you for your kind words, esteemed Diego. I would like to start, first of all, by expressing my gratitude to the United Nations Special Rapporteur on the independence of judges and lawyers, Diego Garcia-Sayan, which is also one of the members of the advisory board of the Global Judicial Integrity Network. And of course, big thank you for inviting us to participate in such an important event, an ancillary meeting during the 14th United Nations Congress on Crime Prevention and Criminal Justice. From my side, I feel honored to share the panel with the distinguished panelists to whom I convey my best greetings. Some of them are also my friends. And on the topic that we think is crucial for the discussions of today and for our world, I would say. Judicial independence is an essential precondition for the existence of rule of law. Judicial independence means that judges and judiciaries are not subjected to external influences in the performance of their functional duties or judicial duties. However, we see today, and some of the panelists addressed this before me, multiple challenges arising that may jeopardize judicial independence, such as the influence of organized crime in the judiciary or interference of other branches of the government, to name just a few of those challenges. We are now in our societies, these challenges have been exacerbated due to the context of the current pandemic. To respond to these contemporary challenges at the global level, we need to work together. In this regard, I would like to quote the UN Secretary General, Mr. Antonio Guterres, when he says, "The challenges ahead clearly demand a more inclusive and clearly demand a more networking based on multilateralism. This is why we work and conducted inside of UNODC to create the Global Judicial Integrity Network that is, we think, relevant for today's discussions." Please allow me to share a little bit more about our work and the work of UNODC. UNODC has worked on the topic of judicial independence and judicial integrity for more than 2 decades, under its specific mandate as a guardian of the UN Convention Against Corruption, UNCAC. which is the only legal binding global instrument against corruption designed to help states both to prevent and to combat corruption. In its Article 11, UNCAC established a mandatory provision for member states to maintain independence and to strengthen integrity among members of the judiciary. Judicial independence and integrity are interrelated. Both principles are provided and aim to provide the judiciary with legitimacy in the exercise of justice, and in return, this legitimacy is obviously high part of safeguarding the rule of law. Article 11 builds on multiple international sources to establish the principles of judicial independence, integrity, and accountability. The UN Basic Principles on the Independence of the Judiciary being one of the most relevant of those sources for the Article 11 of UNCAC. The basic principles were formulated to assist member states in their tasks of guaranteeing and promoting the independence of the judiciary, and today's event, celebrating the 36th anniversary, keeps in mind and in purpose, obviously, these principles that I would like also to mention, together with Bangalore Principles of Judicial Conduct, are key resources for strengthening judicial independence and integrity, and provide guidance to judges when face the contemporary challenges. UNODC in 2016, under the Global Programme for the Implementation of Doha Declaration, to assist the member states in the areas of youth education, crime prevention, prison rehabilitation, and judicial integrity, we launched our global program with the generous support of the State of Qatar. And judicial integrity component is one of the key pillars of our global program that aims to promote and assist the judiciaries across the globe in strengthening judicial integrity and preventing corruption in the justice sector, in line with Article and the provisions of Article 11 of UNCAC. The Global Judicial Integrity Network was launched in 2018 and is a cornerstone of our work. The network has already reached more than 220,000 participants from 189 countries. The success of this initiative, that is a platform by judges for judges that supports judiciary in developing strategies and tools to strengthen integrity in the justice system, works directly with judges, places judges in the driver's seat and the planning seat, and I would say providing us with the strategic guidance of our initiatives to promote independence and integrity on the judiciary. Its legitimacy and engagement with judiciaries around the world has been growing and strengthening tremendously in the last 3 years since its launch. For example, during the high-level meeting of the Global Judicial Integrity Network, held in February 2020 in Doha, we gathered more than 700 participants from 118 countries, including also, and very important to us, 50 judicial associations. And this became the largest gathering of judges and under the auspices of the United Nations. That reveals and shows basically the proactivity of the network and its relevance. The network works based on thematic priorities. The priorities issues of the network in its first working plan included the illegal interference and external interference on the judiciary, independence and integrity. Also, the ethical use of social media by judges, and obviously gender-related judicial integrity issues, and also how to effectively develop and implement codes of judicial conduct. And issues, obviously, that the network provided and developed tools to assist the judiciaries and knowledge products on those dimensions. The network's plan follows the recommendation of advisory board, and the advisory board is comprised by senior judges and representatives of key international and regional judicial associations for all the regions. And among its members, I'm pleased to be accompanied today by Diego Garcia-Sayan, also Honorable Judge José Igreja, which is both of them are part of our advisory board. And thank you both of you for your time, for your wisdom and guidance for the work of the network. The network will continue to focus on contemporary challenges that might represent influence, a negative influence on the work of the judiciary, and they are reflected in the second work plan for the period 2021 of the network. Having this in mind, our focus will be in some thematic priority areas like the use of artificial intelligence in the administration of justice, the promotion of transparency and public confidence of the judiciary, and of course we tried also to explore another important topic of today's meeting, which is the links between judicial integrity and independence, accountability, immunity, and obviously how this connects also with substantive topics like corruption, human rights, and transnational organized crime. In addition, to address the needs around the globe, several training materials were developed by the network. We call it a package of our judicial ethics training tools that can be implemented by the judiciary, and they are composed of several tools that are very linked and designed in line with the provisions of the Article 11 of UNCAC. And those training tools or training resources are being currently used in 66 jurisdictions around the world that actually used our training tools. And to date, more than 6,700 judges and members of the judiciary are using our ethics training package. I would call it like this. The network also creates a way for judges to connect with each other, to learn from common experiences and benefit from products and tools that might be adapted to their current circumstances. The network is a critical tool for strengthening the effectiveness of the judiciary and its readiness to respond to contemporary issues, to internal and external threats, and how to address them that might undermine judicial independence and to promote judicial integrity. To conclude, and obviously you see in the slide also the link for our website where you consult and can actually be exposed to some of our resources. And to conclude, I would like to thank again Mr. Diego Garcia-Sayan, the Special Rapporteur, for the opportunity to participate in this panel and ancillary meeting, to explore obviously this topic on independence and integrity on the justice system. And it was obviously a pleasure to listen to the previous speakers, to their reflection and their contributions to the panel. Allow me also to reiterate the UNODC compromise and commitment, and specifically the Global Judicial Integrity Network, to continue to work and assist the judiciaries around the globe to strengthen judicial integrity, promote partnerships among judiciary, peer-to-peer support, and especially to be at your disposal to address emerging needs that the judiciary will face around the globe. Special thanks for Alex. Alex Gay is connecting with us from Vienna. Thank you, Alex, for joining us so early. And I remain at your disposal, esteemed Diego, for any future interaction. Thank you very much. Over to you, Diego.
Thank you very much, Marco, for this very clear presentation in which it explains very well the interaction between independence and integrity in all the work, the fantastic work that is being done through the Global Integrity Network, so to strengthen these principles. I wonder, through the assistance to Sara, there are some questions for people following the event, or if it is not the case, if I can ask a couple of questions to our colleagues, our participants now. There are some questions, Sara?
No, we don't have any questions yet. If y'all are open to taking questions from the audience and they want to send some in the comments, they can go ahead. If not, Diego, you can go ahead and ask the questions you have.
Okay, perhaps in this case, because it was not announced at the beginning, but in any case, I will ask one very specific question to our friends, eventually in the order in which the presentations have been made. eventually, and of course, without the possibility to have our two friends that have been following the event with video. What specific steps would you suggest to increase the strength of this activity oriented to strengthen independence of the judiciary, independence of the public prosecutorial institutions? One or two key concepts that can help eventually at the national level or at the multilateral level to advance additionally in that step. Perhaps if Jose is around, perhaps he can give some first reaction.
Sure. I hope you can listen. Well, I must say that regarding your question, Diego, I always tend to say that the work that was provided during the past decades by United Nations and by many other international institutions, particularly in Europe, we have gained a large set of instruments, of international standards, of rules, of norms that are very, very coherent, very detailed, and that can be used by national judiciaries. I think the problem now for rule of law, it's not a problem of interpretation, because rule of law is a very solid and stable concept. It's more a problem of implementation. I think the main thing for us now, as I try to address in my speech, it will be that the recommendations, the guidelines, the standards, most of them compiled by the Global Judicial Integrity Network, all the reports produced by the Special Rapporteur for the Independence of Judges and Lawyers could be really implemented on the field, on the concrete field, on concrete ground where judges and prosecutors work. If we achieve that, I think rule of law and human rights will be much more easily understood by the citizens and complied by the governments.
Thank you, Jose. I don't know whoever is in the group. Eventually, Q Juan, if you want to make a contribution regarding this question, Q.
Thank you, Diego, giving me a floor. I would like to reiterate the cooperation and solid cooperation among the prosecutors around the world to achieve our goal of independence, of integrity. So I already explained a lot of measures we have pursued. So from now on, not only prosecutors, but also other area, the lawyers, I hope, get together to enhance the independence and integrity of the judicial areas, and then overall rule of law. So please refer to what I mentioned of my presentation. Thank you.
Thank you very much, Q. And Marco Teixeira, you have just spoken, but eventually you want to make an additional comment?
Thank you, Diego. Actually, if I may, 2 comments, but very short. I promise to be very straight to the point. I fully agree with my predecessors in what they mentioned, especially when our esteemed colleague Jose mentioned that the concepts are clear and the frameworks are existing, are very clear. And even I would go further, that the normative side, the normative setting is already well established. The question is how we implement it, which I want to obviously echo this. And at the multilateral level, at the UNODC side, from the Global Integrity Judicial Integrity Network, our effort is to continue to have this global movement to support actually the promotion of independence and integrity around the functioning of the judicial systems. This is the first point I want to mention. The second point is how we try to mitigate emerging threats that actually affect the independence and integrity. And I want specifically to pick one point, which is very linked with transnational organized crime and the last developments that judges are being exactly targeted to try to undermine their independence and try to have unlawful interference in their decision-making process, and obviously creating a culture of fear. And this is something that we, as a global community, as United Nations Office on Drugs and Crime, might potentially want to work with the member states and judiciary. How can we try to shield the judicial function from this unlawful interference, I would say. This was the 2 points I wanted to make, Diego. Over to you. Thank you.
Thank you very much, Marco. And then I have some questions. I will catch a couple of them, and perhaps with with this, we can wrap up the meeting. Yasushi Hisaisawa, he's from the University of Kyoto. He asked about the difficulties to deal eventually with when attacks against independence come from the executives, and how in not fully democratized society, how can international cooperation and solidarity can improve and encourage some changes. A very important matter, because in some cases, let me catch this question. In some cases, a strong criticism, duly based in substantial information, can eventually generate a climate in which some review of an ongoing negative situation is taking place. And in some cases, that has led to certain sectors of the political areas in which eventually between the option to generate a conflict, generate a tension with the international community, or improve the rule of law and respect for independence of judges, in many cases, people do choose this second route. And that is not the case always. And of course, in which a confrontational situation is reached, in which, for instance, judges are not only pressed to not be independent, but eventually detained, eventually killed, as is happening in some countries of the world. And that, of course, requires different elements of information, persuasion, and eventually political pressure. And there is other question, very specifically presented by Karol Skiba about Poland. He says, what is your take on the situation of the judiciary in Poland? I wouldn't like to enter in a specific comment about any country in this side event. I refer to the report I presented a couple of years ago after an official visit I made to Poland, in which the substance of the report was that there was a big problem, and I quoted, I began my press conference in Warsaw when I finished my visit. The judiciary is under attack, which says a lot about what was my view. 2 years ago, the situation has not improved, unfortunately. And anyway, I see very positively as well that the international community, especially the European Commission, is advancing very positively to present very clearly the view of Europe, the democratic Europe, that there are certain things that cannot be accepted in Europe, that are certain things that cannot be accepted in the world, in which the political control of the judiciary is not a way in which things should work in a democratic state, in a democratic society. I refer, Carol, to the report I presented, and of course, to several publications that we have done in the last 2 years. There are problems in Poland, as there are problems in many other parts of the world. So at this stage, dear friends, in which we have had really fantastic presentations from our guests, I do express again my deep appreciation for their presence, and my deep appreciation for their fantastic contributions, for the consistency of all of them, and for the real interaction and combination of views in which I see that like in a puzzle, all the different pieces finally can give a very beautiful view about how the future can improve in the world, how an independent judiciary and independent prosecutorial offices are not only necessary but viable, in which leaders in that aspect play a role, chief justices, a judge from international criminal court, in which these views are really shared by persons which are riding the horses of institutions and judicial institutions. We must prefer to be optimistic than pessimistic in this real negative context in some very specific countries. So please, I want to again give my appreciation to the participants for the very valuable, fantastic presentations, and my appreciation for the person that have helped us to make this side event viable, Sarah Reyes and many others, and of course for the friends that have followed this presentation through the internet. My appreciation and my thanks as well. Thank you very much.
Thank you, Diego. Thank you to all. See you soon.
Thank you. See you soon.